We've now reached the most central, most substantial part of this training course, because here we're talking specifically about the relationship between copyright law and generative AI. So these are the three main issues that arise every time we talk about copyright and generative artificial intelligence systems. So the first one, are works created with these artificial intelligence systems protected by copyright? No, because this is already an important first question to ask. Because if we take the example of that Reficanador installation where individual images are extracted, in that case, since there is no human supervision at all, some jurists, some copyright law experts have argued that there is simply no copyright there, and therefore it makes no sense to discuss what kind of protection should apply to that type of image. However, in other cases, artificial intelligence is simply a tool in the hands of authors, of individuals, of human beings who create and use these tools to create. So in this case, if the works are protected, in what terms are they protected? What kind of rights or restrictions apply to these works? And this is only the first of the three questions. Then we have a second question, which is how can I determine where the human intervention ends and the machine's begins? Because in a work created with artificial intelligence systems, given how well these systems now function, how sophisticated and high-performing they are, the person experiencing these works cannot tell where the human intervention is and where the machine's contribution begins. Until a few years ago, an expert in the field was able to tell if a photograph had been modified with Photoshop and in what way, or if a text had been reworked in a certain way by an automated system. Now it is becoming much, much more difficult. And so when I can no longer distinguish where the human intervention ends and the machine's begins, this also affects the issue of copyright. Because if copyright only exists where there is a creative human intervention, it is important to know where that boundary lies. Is that clear? The third question, who holds the rights to these works? Because if we come to the conclusion that works created with artificial intelligence systems are still subject to copyright, who actually holds those rights? Only the individual person who has truly and genuinely initiated the entire creative process and meticulously directed it from its very inception, or also the one who carefully created the sophisticated artificial intelligence system and subsequently made this complex operation possible and fully functional, or even those who diligently provided the foundational works for the comprehensive training of such a system should be considered. You know that these artificial intelligence systems, in order to be so good, so effective at creating works, have looked at, studied, and imitated many works previously created by humans. So they have been trained with countless millions and millions of images, texts, and music. And so there is a relationship of derivation, meaning that those who created the images used for training can claim copyright and therefore go and challenge or demand accountability from the various users of the artificial intelligence system for their works. These are the three main issues that have emerged and that over the past 2 or 3 years, copyright law has tried to analyze, examine in depth, and provide answers to. We will try to give the answers that we have at least up to this point. One of the first steps was taken by the United States Copyright Office. And if you remember, the advent of these systems for the general public can be placed around October or November 2022, when ChatGPT was released and people really began to understand the potential of these systems. In reality, these systems already existed before, but that was when they really exploded. And everyone began to understand just how revolutionary and impactful they were, even for copyright law. A few months later, as you can see in March 2023, the Copyright Office took a position, and what did it say? It said something that in reality all the legal scholars of the time had already said, myself included. There are even some of my recorded lectures where I had already explained this. But the approach is that artificial intelligence systems should generally be considered as tools in the hands of a human being, and therefore it doesn't make sense to consider them as authors or co-authors of works. Why does the Copyright Office do this? Because during those months, some authors had tried to register some of their works, texts, music, images, created with these artificial intelligence systems at the Copyright Office, declaring as authors, in addition to themselves, also Hello GPT from there, Midjourney, meaning they included the name of the AI software or platform as an author. The Copyright Office had to issue an official statement in which it said, "Thank you. That's enough. Stop doing this." It makes no sense to list software as the author of a work because software is software. It's a machine. And it may seem trivial, but it was an important step because it emphasized and put in writing in an official document this fundamental principle. So, except for particular situations like the ones we mentioned earlier about unsupervised AI, artificial intelligence systems should be considered as tools in the hands of human beings, just like word processing software, word or graphic and photo editing software, Photoshop and the like, were before. Nothing more. So, who holds the copyright on works generated with artificial intelligence systems? The first answer is it depends. It depends. We jurists are very inclined to answer this way. We often respond with it depends because in reality, law is not an exact science. Law refers to precedents, to rules that sometimes are not completely up to date, not entirely clear, and require interpretation, require concrete application, and so it depends is the simplest, most expedient answer to give. But depends on what? Because in reality, it depends is the correct answer, but we need to say depends on what? It depends on these two main variables, okay? So first of all, it depends on whether or not there is creative activity by a human being, okay? So as we said, copyright applies if there is creativity. And so if there is no creative activity whatsoever by a human being, then we cannot talk about copyright. So if there is creativity, copyright generally belongs to the author who created the work using an artificial intelligence system. If there is no human intervention at all, like in the example I gave you earlier, of that image isolated and turned into an NFT by an automated process created by software, then perhaps because we still don't have solid rulings or established case law on this, perhaps there is no right at all. So that single image would be in the public domain from the very beginning without any copyright attached to it. The second variable, therefore, also depends on another factor. That is, it also depends on the terms of use of the individual application used, of the artificial intelligence service used. In the final part, Chapter 5 of this course is dedicated precisely to the terms of use of these systems. That is, the terms of use of these systems always include a paragraph or an article specifying how rights are managed, meaning to whom the rights of use are attributed. Okay? But I would say that the main variable is the first one, whether or not there is a human creative activity. Let's continue. And this is one of the main misunderstandings and misconceptions about generative artificial intelligence. That is, we need to understand that generative artificial intelligence is not something that goes looking for a work similar to the one I requested and modifies it to provide me with something. Or it doesn't go looking for many works similar to the one I requested, put them together, make a sort of collage or mashup, and then give me the result. It doesn't work like that. So it doesn't have a database of images to draw from. It has learned to do things in a way very similar to how humans do them. So, the extensive training activity has genuinely allowed it to learn and understand precisely how to effectively respond to my various prompts, sometimes with remarkable effectiveness, and sometimes even quite proactively, meaning it thoughtfully suggests something truly valuable to me. This often goes significantly beyond what I had initially imagined or even considered thinking of, providing truly insightful contributions. So, what's truly interesting to fully understand and grasp is that there's a sophisticated learning process that effectively emulates genuine human creative activity, and there isn't a corresponding process of extensively reworking or comprehensively remixing previous artistic works or creations. Because if we keep thinking that there's just a remixing of pre existing things, it's clear that we fall into the misconception that using artificial intelligence systems will always lead us to copyright infringement. Because in order to create an image, I'm using a tool that puts together things made by others without asking their permission. So clearly there will be a copyright infringement issue. Instead, they work differently, and this is extremely important to understand. the legal cases that have occurred so far on this particular topic are almost all exclusively found in the United States. And they have focused precisely on this, that is, on the potential copyright infringement resulting from the training activity of these artificial intelligence systems. In other words, the various companies that have created these generative artificial intelligence systems have trained them by taking literally millions and millions or even billions of pieces of content from the internet and using them to study and understand how humans create these things in order to build a machine that is very good at imitating human creativity. This is precisely the issue. Did these companies violate copyright in carrying out this activity? Did they have the necessary authorizations? Did they ask permission from the various rights holders? Did they obtain usage licenses? And so all the various lawsuits for copyright infringement have more or less focused on this aspect. However, there are a few notes to be made here. A good portion of these legal cases, as I mentioned, are before US courts. And so, first of all, in the United States, there is the principle of fair use, which works differently compared to our exceptions to copyright. And also, in the United States, there is no sui generis right, meaning that databases are protected in a different way compared to, it's also somewhat lighter compared to what happens in Europe. And then everything depends on two fundamental issues, because fair use in the United States applies, it is triggered when there is a sufficiently transformative activity on the work. Enough transformative. And so the fundamental question that arises is whether the extensive training activity and the subsequent development of sophisticated artificial intelligence systems are sufficiently transformative in nature for the well-established fair use principle to be legitimately applied in these specific circumstances. And the other major problem that has arisen in all these cases is that sometimes it is very difficult to actually prove the violation before the judge. That is to say, let's assume it's vaguely clear where the specific sources utilized to meticulously train the sophisticated artificial intelligence system were actually taken from. But American law, specifically American procedural law, absolutely requires a thorough and comprehensive double check. In proving the actual violation, and this crucial proof has always been very difficult to adequately provide, so many legal cases have unfortunately stalled due to a significant lack of compelling evidence. Thank you. We've also concluded this part. As you can see here, we've moved much more onto a legal level. I hope I've provided you with concepts that are rich in content and food for thought. And now let's continue and head towards the end. Thank you.